Okay, good afternoon, class. So we'll proceed with our discussions on general provisions. Okay, so Declaration of Basic Policy, which is found in Article 3 of our Labor Code. Okay, so the state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self organization, collective bargaining, security of tenure, and just and humane conditions of work. Now, class, Article 3 of the Labor Code lays down the fundamental labor policy of the state. So it establishes that labor is not merely a commodity, but a protected sector, central to national development. So for HRDM students, this provision serves as the ethical and legal foundation of human resources practices. Now, number one is state protection to labor. So the state's duty to afford protection to labor means that laws, policies, and institutions must favor workers' welfare, especially because of the inherent imbalance of power between employers and employees. Now, what does its implication? No, HR managers must design policies that uphold fairness, dignity, and employee welfare, not just productivity and profit. Now, with regards to the promotion of full employment means creating conditions where all who are willing and able to work can find decent and productive employment. So, its implication for HRDM is strategic workforce planning, skills development and training programs. Take note that HR is not only hiring, no, it is developing people to maintain employable. Next, we have equal work opportunities. So the law guarantees equality, no, regardless of sex, race, or creed, reinforcing the principle of non-discrimination. So its implication for HR people, no, should have fair recruitment and selection process, equal pay for equal work, inclusive workplace policies, and discrimination exposes organizations to legal, ethical, and reputational risks. With regards to regulation of employer-employee relations, class, the state intervenes to ensure balance, peace, and fairness in labor relations. Again, I have always mentioned this that HR people serves as a bridge between management and employees. So, you handle grievances, no, you handle negotiations and even conflict resolutions. Next, we have the right to self organization. So, workers have the right to form or join unions without interference. Um, HR must respect union rights and avoid unfair labor practices. Take note that unionization should be seen as a legitimate voice mechanism, not a threat. Of course, we have collective bargaining. So this right allows workers and employers to negotiate wages, benefits, and working conditions. Now, HR professionals play a key role in good faith bargaining, ensuring compliance with agreements and fostering industrial peace. Then we have security of tenure. So employees cannot be dismissed without just or authorized causes and due process, right? So, its implication for HR people is you have to have proper documentation, you need to observe due process, and you should be clear, no, on your disciplinary procedures. Take note, termination is a last resort, not a management shortcut. Then last, we have the just and humane conditions of work. So, work must respect human dignity, health, and safety. So its implication for HR people is you should be, or the company should be occupational safety and health compliance, no? Like reasonable working hours, mental health and well-being programs. Take note that a humane workplace leads to higher morale, productivity, and retention. So, Article 3 class reminds us that HR is not merely administrative, no? It is moral, legal, and developmental. So, an effective HR professional balances organizational goals, employee rights, and social responsibility. Now, let's move. Okay, we now move on to the rights of employees and workers. Now, these rights class are grounded in the Constitution and the Labor Code, and they exist to protect labor as a social and economic force. So, let's go through them briefly but meaningfully. First is equal work opportunities for all. So, this means employment should be free from discrimination. As a rule, access to work must be based on merit, disqualifications, and fitness, not on gender, status, and other arbitrary grounds. Second is security of tenure. This is one of the most important rights of workers. An employee cannot be dismissed except for a just or authorized cause, and only after due process. Employment is not at the mercy of the employer's whim. Third is work days and work hours. So the law regulates normal working hours to prevent exploitation and overwork. This includes rules on overtime, night work, and premium pay. Fourth is the weekly rest day. So workers are entitled to a rest day after 6 consecutive days of work. This right recognizes the need for physical, mental, and family well being. Fifth is wage and wage related benefits. So this includes minimum wage, holiday pay, service incentive leave, 13-month pay, and other monetary benefits provided by law or agreement. Six is payment of wages. So wages must be paid on time in legal tender and directly to the employee, subject only to lawful deductions. Delayed or withheld wages violate labor standards. Seven, um, protection of female employees. So the law provides special protections such as maternity benefits, protection against discrimination, and safeguards for women's health and dignity in the workplace. Eight, we have regulation on the employment of children. So as a rule, child labor is prohibited. Only limited exceptions are allowed, and always with strict conditions to protect the child's welfare, education, and development. Ninth is safe and healthy working conditions. Employers are duty bound to provide a workplace that is safe, sanitary, and not hazardous to life or health. And tenth is the right to self organization and collective bargaining. Workers' class have the right to form unions, join collective bargaining, and negotiate terms and conditions of employment to balance the inherent inequality between labor and capital. Now, these rights class exists to ensure dignity, fairness, and protection for workers, recognizing that labor is not just a commodity, but a partner in nation building. Now, with regards to equal opportunities and non-discrimination, this portion class of Article 3 of the Labor Code underscores the state's obligation to ensure equal work opportunities, regardless of sex, gender, or creed. So it affirms that access to employment and fair treatment of work must be based on merit and qualifications, not personal characteristics unrelated to job performances. Now, the law prohibits discrimination in hiring and recruitment, promotion and training, compensation and benefits, employment terms and conditions. Now, an employer cannot favor or disfavor an applicant or employee solely because of sex, race, or religious belief. Now, for HR professionals, this policy translates into objective and transparent HR system. With regards to recruitment and selection, job requirements must be job related. Gender based preferences are allowed only when they are bona fide occupational qualifications. Now, with regards to performance management, evaluation must be based on performance indicators, not stereotypes or personal bias. With regards to compensation and benefits, equal pay for equal work. So wage disparities must be justifiable and documented. There are practical examples, class, on unlawful practice. No? So like refusing to hire a woman because the job is for men. No? So uh, lawful practice is hiring based on skills, experience, and competence. Now, why this matters in HRDM class? Now, this is take note that non-discrimination promotes fairness and equity, employee morale and trust, productivity and retention, and compliance with labor laws. Take note, class, that discrimination is not just unethical, it exposes the organization to legal liability. Um, there are present laws that prohibits discrimination against women employee class. That's Article 35, 135 rather of the Labor Code. Neither may an employer hire or promote someone just because that person is a Chinoy or has a Chinese sounding name, and neither may an employer prefer to hire a Christian over a non-Christian or vice versa solely on account of the creed. Likewise, giving a foreign hire salary higher than that for a local hire is discriminatory if they have the same jobs. Similarly, Republic Act 7277, Section 5, or the Magna Carta of Disabled Persons provides that no disabled person shall be denied access to opportunities for suitable employment, and that the terms and conditions of employment of a qualified disabled employee must be the same as those of qualified able-bodied person. Now, question. Is it legal for an employer to prefer someone with pleasant personality or high scholastic rating or someone who graduated from school A over another uh who who came from school B? Um, take note, class, that employee selection on the basis of personality or skills possessed or educational background does not appear to be controlled by our present laws. In the answer to our question is it could be legal provided the preference is job related, reasonable, and not a disguise for prohibited discrimination. So the legal basis for this one is Article 3 of the Labor Code, which prohibits discrimination based on sex, race, or creed. It does not it does not prohibit employers from setting reasonable employment standards. So, um, kanusa man ni siya mahimong legal or when the preference is legal with regards to pleasant personality. Legal if the job requires customer interaction, public relations, sales or service roles. Also like hiring a front desk staff with good communication skills. So legal na siya. Not legal if used to mask bias, like rejecting applicants because of appearance or gender stereotype. With regards to high scholastic rating, it is legal if academic performance is relevant to the job competence. The standard is applied equally to all applicants. So, example, an entry-level analyst or research positions. It is not legal if used arbitrarily or inconsistently. Now, with regards to graduate of school A versus school B, this is legal if the preference is based on recognized training, accreditation, or specialization. So it is related to job requirements. Example, hiring engineers from schools known for specialized engineering programs. This is not legal class if the preference results in systematic exclusion unrelated to job performance. Again, class, when the preference becomes illegal, when it is based on or results in discrimination because of sex, race, or creed. So if it serves as a pretext to hide unlawful discrimination. So we have rule of the thumb for HRDM. No? Employment standards must be job related, objective, and consistently applied. So as an HR, you must always ask, is this requirement necessary for the job? Is it fair and reasonable? Is it free from bias? No? Because take note, management prerogative is not absolute. It must always yield to labor protection, equal opportunity, and social justice principles. Take note, class, that good HR decisions balance competence, fairness, and legality. Now, what about age? So, may an employer prefer legally to hire a young applicant or to replace an older employee with a younger one? So, as a general rule, class, age by itself is not a lawful ground for discrimination. So, an employer cannot simply prefer a young worker or replace an older one solely because of age. This would violate the state's policy of protection to labor and the principle of equal opportunity under Article 3 of the Labor Code. So, kanus aman pwede mamahimong uh, mapwede no nga age-based ang preference. So age may be considered only if it is a bona fide occupational qualification or what we call BFOQ. So that is when age is reasonably necessary to the nature of the job. So for example, jobs requiring exceptional physical stamina like professional athletes. So of course, uh, pwede nga na ay age limit. Also, rules with statutory age limits like pilots, firefighters, law enforcement, which is set by law. So even then, the employer must show that no reasonable alternative exists. So it is illegal class when hiring younger workers not to pay lower wages. It is also illegal replacing older employees to appear more energetic or modern, and terminating employees close to retirement to avoid benefits. These acts may constitute illegal dismissal or unfair labor practice. So, management prerogative does not include the right to discriminate. So, age alone is never enough. Before class, unlike the US, which has the Age Discrimination in Employment Act, the Philippines has no law no prohibiting discriminatory hiring on the basis of age. But now, uh, a law on this matter exists. So this is RA 10911. So this is anti-age discrimination in employment. So this prohibits arbitrary age limitations in employment. This promotes employment of individuals on the basis of abilities and qualifications, as well as the right of employees, regardless of age, to be treated equally in terms of compensation, benefits, promotion, and other employment opportunities. This bill class was passed in May 2016 and lapsed into law without presidential signature. The implementing rules are contained in Department Order number 170-17, issued on February 2, 2017. The law and the implementing rules do not absolutely prohibit consideration of the applicant's or employee's age in employment policy or decisions. Of course, exceptions are recognized. So, and one broad exception recognizes the bona fide occupational qualification. So, what does it mean? What does bona fide occupational qualification mean? So, if age is a bona fide occupational qualification or necessary in the normal operation of the particular business, or where the differentiation is based on reasonable factors other than age. So it means that again, um, if age is really a necessary factor in a job, then it is not considered a discrimination. And therefore, the employer can set age limit for a requirement. Now, there are some examples of bona fide occupational qualification that are allowable. One is with airline pilots and bus drivers, no, who are assigned a mandatory retirement age. Also, church employees who must be a member of the denomination to fulfill job duties, and model or actors who need to show authenticity in a role. Um, what is an example of a bona fide occupational qualification exception? So BFOQ exception applies where an employer can prove that an employment preference based on one of these protected class characteristics is reasonably necessary to the normal operation of its particular business or enterprise. So, for example, a woman's clothing store may legitimately hire female rather than male models. Another example class is kanang weight requirement bitaw. Um, so for mga flight attendants, BFOQ nga naa salay weight requirement and even height requirements. So note that to invoke any of the exceptions, the employer is required prior to the implementation to submit a report to the Dole Regional Office, which has jurisdiction over the workplace. Failure to submit such report shall give rise to the presumption that the employer is not allowed to set in age limitation. Now, let's move on to management's rights, or what we call management's prerogative. So the Constitution is committed to the policy of social justice and the protection of the working class. But it should not be supposed that every labor dispute will be automatically decided in favor of labor. Management has also its own rights, which, as such, are entitled to respect and enforcement in the interest of simple fair play. Now, out of its concern for those with less privileges in life, The Supreme Court has inclined more often than not toward the worker and upheld this cause in his conflicts with the employer. Such favoritism, however, has not blinded the court to the rule that justice is in every case for the deserving to be dispensed in the light of the established facts and applicable law and doctrine. It is a fundamental state policy, according to the Constitution, to encourage private enterprise. Let's talk about the concept of management prerogative. So, under the doctrine of management prerogative, every employer has the inherent right to regulate, according to his own discretion and judgment, all aspects of employment, including hiring, work assignments, working methods, the time, place, and manner of work, work supervision, transfer of employees, layoff of workers, and discipline, dismissal, and recall it all uh, employees. So, indeed, the manner in which management conducts its own affairs to achieve it, its purpose is within the management discretion. The only limitations to the exercise of this prerogative are those imposed by labor laws and the principle of equity and substantial justice. The policies, rules, and regulations on work related activities of the employees must always be fair and reasonable, and the corresponding penalties in enforcing discipline in the workplace must be commensurate to the offense involved and to the degree of the infraction. Now, constitutional despite the constitutional mandate to afford full protection to labor, the employer also has certain rights that need to be recognized. No? Again, the employer enjoys what are commonly known as management prerogative, where interference with an employer's judgment in the conduct of its business is discouraged. So, management prerogative refers to the employer's right to control and direct business operations subject to law, contracts, and fairness. There are of course pros and cons, no? So one of the pros is the operational efficiency. It allows management to assign work, set schedules, and design workflows necessary for productivity. Then we have business flexibility. So this enables employers to adapt quickly to market changes, technology, and economic conditions. Another one is we have clear accountability. So it clarifies who makes decisions, reducing confusion and delays in operations. Then we have performance management. So this empowers management to discipline, reward, or sanction employees based on the merit and performance, of course, with due process. Then the last one would be business sustainability. So this helps ensure profitability and continuity, which ultimately protects jobs. Now, what about its cons or its risks? One is potential for abuse. So, management prerogative, if exercised arbitrarily or in bad faith, it may lead to oppression or unfair labor practices. Next, erosion of employee trust. So, excessive control can lower morale and damage labor management relations. Then we have legal exposures. Decisions that ignore labor laws, due process, and contracts can result in labor disputes and liabilities. And then we have conflict with social justice goals. So, overemphasis on management rights may undermine the state's policy of protecting labor. And then we have resistance and industrial unrest. So, purely communicated or unjust decisions may trigger grievances, union action, or strikes. Now, management prerogative is valid, take note, but never absolute. It must always be exercised in good faith, with fair play, in compliance with labor laws, and with respect to employees' rights. So, let's talk about uh, what are these rights of the management. It is important to know that management, again, has rights that needs to be respected. Number one, we have the right to return of investments. So the employer has the right to recover his investment and to make profit. There is nothing dirty about profit per se. It is profit that creates jobs and improves the workers' life. The Constitution provides that the state shall regulate the relations between workers and employers, recognizing the right not only of labor to its just share in the fruits of production, but also the right of enterprise to reasonable returns on investments and to expansion and growth. Then we have the right to prescribe rules. So employers have the right to make reasonable rules and regulations for the government of their employees. And when employees with knowledge of an established rule enter the service, the rule becomes part of the contract of employment. Then the right to select employees. So an employer has the right to select his employees and to decide when to engage them. The state has no right to interfere in a private employment and stipulate for the parties the terms and services to be rendered. Not Surely not even the government may interfere with the liberty of employers to stipulate with its employees the employment terms and conditions, except in its exercise of its regulatory power. If the employer can compel the employee to work against the latter's will, this is servitude. If the employee can compel the employer to give him work against the employer's will, this is oppression. And the last one is the right to transfer or discharge employees. The employer has the right to transfer, reduce, or lay off personnel in order to minimize expenses and to ensure the stability of the business. It may even decide to close the business, provided that the resulting transfer or dismissals are done in good faith and are due to causes beyond control. To hold otherwise would be oppressive and inhumane. Now, um, let's talk about the limitations, no, to management prerogative. Now, labor standard is one of the limitation to management prerogative. Management prerogative allows employers to run their business, but it stops where labor standards begin. So labor standards represents the minimum non-negotiable protection granted by work to workers by law. Okay, again, labor standards are the minimum requirements prescribed by law on wages and wage-related benefits, hours of work and rest periods, cost of living allowance, monetary and welfare benefits, and occupational safety and health standards. As held in the case of Maternity Children's Hospital versus Secretary of Labor, these standards are mandatory and cannot be waived. Now, as to the limitations on freedom of contract, while the employers and employees may agree on employment terms, such agreement cannot go below the legal minimum. So, parties may stipulate terms above the minimum. So, pwede above sa minimum. For example, ang minimum wage na to is 470. So, if they stipulate 500, that's okay. But, dili pwede nga below the minimum. Any contract or policy that diminishes labor standards is void for being contrary to law and public policy. So for HR practitioners, this means that company policies must be law compliant by design. Cost cutting measures cannot reduce statutory benefits. Efficiency programs must respect wage, hour, and safety laws. And business necessity is not a defense against violation of labor standards. Mm. So class management prerogative operates within the boundaries set by labor standard. So therefore, labor standards serve as a floor, not a ceiling, a safeguard, not as a suggestion. Let's talk about the rules on fairness now as limitations to management prerogative. Now, management prerogative allows employers to make decisions necessary for business survival. However, it cannot be used as a shield for unfairness or discrimination. So, an employer class cannot justify discriminatory acts by merely invoking management prerogative. What the law prohibits cannot be legitimized by management discretion. So, if a policy or action results in unequal treatment without a valid and reasonable basis, it is unlawful. The law recognizes the employer's right to retrench to prevent losses, close or cease business operations. However, the manner of exercise must be fair. Take note that retrenchment or closure does not justify unequal payment of separation benefits, arbitrary selection of employees to be dismissed, and discriminatory treatment among similarly situated workers. Now, employers who are similarly situated must be treated alike. Giving higher separation pay to some employees and lower pay to others without valid justification is unfair, even if retrenchment is valid. Take note, class, that differentiation must be based on reasonable and objective criteria, like, for example, the length of service, its position, and legal qualification. Let's talk about the scope of management prerogatives. So, management prerogative class is a bundle of rights by the employer which covers pre-employment to post-employment, to post-employment, such as one, hiring. So, as to who will be hired in a pool of candidates, the employer has the complete discretion to choose among them and offer a contract of employment. Next, we have work assignments. So, in terms of giving work assignments, the employer has the right and prerogative which among the employees would be best suited to do the work. Then we have working methods. The employer determines what steps, processes, or methodology that would be observed in doing a particular work. As the owner of the business, the employer is expected to have the necessary knowledge, skills, and competence to assess the best way to perform the work. Next is the time, place, and manner of work. So as to when and where work will be done, as well as what by what manner, the employer has the right to decide to ensure that work is done productively and efficiently. Still, the employer should ensure that this should be communicated to applicants who intended to be employed to be properly appraised of work hours and work days, days of assignment, and what skills may be necessary to accomplish the work. Next is work supervision. So the employer has the right and prerogative to supervise the work being done by its employees. So this is rightly so since the employer is responsible for any damage or loss caused by employees while in the performance of their work by virtue of vicarious liability. Hence, the employer has the duty or responsibility to ensure that work is being correctly and or proper precautions are being observed, such as wearing protective personal equipment. Next is transfer of employees. So if there is legitimate reasons for doing so, an employer may transfer employees from one unit or department to another, as well as deploy or relocate an employee from one workplace to another. Note that while it is the right of an employer to transfer employees, such right is subject to certain limitations, such as good faith on the part of the employer. So meaning, dili nimo pwede ibalhin ang usa ka employee just because dili ka ganahan makakita sa iyang nawong. Next is layoff of employees. So when circumstances justify or warranted, the employer may put the business under temporary work suspension, which may result in employees being temporarily laid off. Once the establishment recovers, the employer may recall workers to return to work and continue with their employment. However, the employer may exercise retrenchment or permanently lay off certain employees. Next is discipline and dismissal. So the employer has the right to discipline erring employees who have been proven to commit violations, provided that due process is observed. So in the infractions, or rather, if the infractions are grave and serious that would amount to a just cause for termination of employment, the employer has the right to dismiss them. And the last one is recall. So once the establishment recovers, the employer may recall workers to return to work and continue with their employment. However, the employer may exercise retrenchment or permanently lay off certain employees. Now, note class that the above enumerated list is not exhaustive and only a sample. So long as it involves regulating any aspect of employment, it is covered by management prerogative. All right. Management prerogative class are not magic words uttered by an employer to bring him to a realm where our labor laws cannot reach. So that is enunciated in the case of SPI Technologies Incorporated versus Mapua, GR number 191154, April 7, 2014. The exercise of management prerogative again is not absolute. By its very nature, encompassing as it could be, management prerogative must be exercised, number one, in good faith and with due regard to the rights of labor or the employee's rights. While we concede that management would best know its operational needs, the exercise of management prerogative cannot be utilized as an implement to circumvent our laws and oppress employees. The prerogative accorded management cannot defeat the very purpose for which our labor laws exist, to balance the conflicting interest of our labor and management, not to tilt the scale in favor of one over the other, but to guarantee that labor and management stand on equal footing when bargaining in good faith with another. Now, while the law recognizes and safeguards the right of an employer to exercise what are certainly management prerogatives, such rights should not be abused and used as a tool of oppression against labor. The company's prerogatives must be exercised in good faith and again with due regard to the rights of labor. So let's talk about what good faith means. No? Good faith as a limitation to management prerogative. Good faith means that managerial decisions are made for legitimate business reasons. It's free from malice, arbitrariness, or ill motives. This is intended to promote business efficiency, not to punish or harass employees. Now, management power is valid only when exercised honestly and reasonably. Um, an employer may validly transfer, no, an employee without demotion or diminution of benefits if the transfer is required by necessary or by business necessity. The employee's skills or expertise are genuinely needed somewhere else. So the transfer is not a disguise penalty. So kana nga transfer of employees um is considered an exercise of management prerogative in good faith. Um, Take note, class, that if a lawful transfer order is issued in good faith and the employee willfully refuses to comply, dismissal may be justified on the ground of willful disobedience. So here, the order must be lawful and reasonable, and the refusal must be intentional and unjustified. Now, take note, class, that um, in the absence of good faith, so there would be liability. No? If the transfer lacks business justification, results in demotion, harassment, or constructive dismissal, or is violated, or rather motivated by bad faith. So the employer in this case may be held liable for illegal dismissal. Now, example, uh, an employer is justified in dismissing who refuses to be transferred to a different branch if such is a business necessity. So meaning like need ang skill ni employee, no, ang iyang skill ug expertise kinahanglan siya sa other branch. So lawful man na siyang exercise of management prerogative o niya ning refuse ang employee nga ibalhin. So that would be just cause termination, which is based on willful disobedience. So, of course, if there is no such justification, an employer may be held liable for illegal dismissal. Like in the case of Pantuha versus SCA Hygiene Product Corporation, the dismissal of a utility man who was separated from service due to his refusal to transfer was held valid after it was established that the company was acting in good faith when it implemented a reorganization plan to address financial difficulties and after due process was observed. Let's talk about the second limitation, the management prerogative should be exercised with due regard to the rights of labor or employees' right. Otherwise stated, the employer should ensure that labor laws which provides for the rights of the employees should be observed. Managerial prerogatives are subject to limitations provided by law, collective bargaining agreements, and general principles of fair play and justice. For instance, an employer cannot validly terminate a rank and file employee who refuses to render overtime work if there is no ground for compulsory overtime work. Unknown to many, DOLE rules prohibit overtime work for rank and file as a general rule However, exceptions are allowed under the rule on compulsory overtime work. Thus, a rank and file employee has a right to refuse overtime work where none of the grounds are present. Now, management prerogatives, however, are subject to limitations also provided by law, collective bargaining, and agreements, and of course, the general principles of fair play and justice that is initiated in the case of Indico versus Quantum Foods Distribution Center, GR number 161615, January 30, 2009. You read this case class for you to be able to understand better on this concept. Okay. Um, we have frequently asked questions on management prerogative. So, what is management prerogative? Again, management prerogative is a bundle of rights inherent to the employer who gets to decide all aspects of employment from pre-employment to post-employment unless limited or regulated by labor law. Now, what are examples of management prerogatives? The exercise of management prerogative come in various forms such as the implementing workplace policies and regulations, enforcing company practices, managing of employees, and so on. So as earlier explained, management prerogative covers from pre-employment to post-employment and everything else in between, including work hours, schedules, work assignments, work supervision, disciplinary action, recall, and so on. What is the legal basis of management prerogative? So the Supreme Court recognized management prerogative as an inherent right of an employer. This means that such bundled rights automatically attach or ensues the moment a business becomes an employer. This is the meaning of it being an inherent right. So since it is an inherent right, no law is needed. Thus, there are no legal provisions pertaining to management prerogative in our 1987 Constitution, in Republic Acts, as well as in older laws such as Presidential Decrees, Batasang Pambansa, and so on. Next, is management prerogative unlimited? The answer is no. Management prerogative is not unlimited. Management prerogative has two general limitations, which are number one, it must be exercised in good faith, and two, it must be exercised with due regard to the rights of the employees. Now, what is the test of good faith? Um, in general, good faith if there is legitimate business reason behind the exercise of management prerogative. Conversely, there is good faith if there is no malice, bad faith, or ill will in the exercise of the employer's rights. Next, what does it mean to say with due regard to the rights of the employees? So the clause refers to the labor law, which is generally the source of employees' rights. Thus, the exercise of management prerogative class should be in compliance with labor laws and regulations to be able to say that employer exercise its rights with due regard to the rights of the employee. Next, may employees question an employer's management prerogative? So in general class, employees may not question the employer's management prerogatives as its exercise enjoy the presumption of good faith and regularity. Thus, employees may not simply refuse to comply with company policies and regulations because they are questioning it. On this point, it should be emphasized that in case employees are seriously damaged or prejudiced, such as losing their employment or not being paid their compensation and benefits, they may file a labor complaint with labor courts to determine the validity or legality of the employer's exercise of its management prerogative.
Next, who determines if the employer properly exercise its management prerogative? So, take note, class, that it is only the labor courts which can determine whether an employer properly exercise its management prerogative. Hence, as earlier stated, employees cannot simply refuse to comply with company policies and regulations because they question their validity. So, if employees strongly believe that the employer is not properly exercising its management prerogative, they may file a labor case to challenge the validity of an employer's management prerogative. Thereafter, it is the labor courts which shall finally decide whether the employer indeed exercise its management prerogative. If the employer abuse its rights, then it may be liable for administrative sanctions with regulatory agencies and or compensations like damages to the employees. Let's move on to Article 4, the construction in favor of labor. So, Article 4 class embodies the state policy of social justice by directing that all doubts in the implementation and interpretation of the labor code and its rules shall be resolved in favor of labor. So, this rule class applies only when there is doubt or ambiguity, no, in the wording of the law, its implementing rules and regulations, and the application of labor standards. So you have to take note this key point, class. When the law is clear, it must be followed. When the law is doubtful, it is interpreted for the worker. Now, what's the rationale behind this? The rule recognizes the unequal bargaining power between employers and employees. So to level the field, the law gives workers the benefit of the doubt. So this does not mean automatic victory for labor, huh? It just means protective interpretation. Now, there are limits of Article 4. So Article 4 applies only to legal doubts, not to question of facts. Also, it cannot be used to defeat clear legal provisions, and it does not excuse employee misconduct or lack of evidence. So, the court will not favor labor when the facts clearly show lawful employer action. So, if, like for example, if a company policy on overtime pay is unclear, the interpretation that favors the employee will prevail. But if the policy is clear and lawful, then Article 4 does not apply. Take note, class. Article 4 is a rule on interpretation, not a rule of favoritism. It ensures fairness by protecting workers only when the law is uncertain. Let's move on to Article 5. Article 5 class authorizes the Department of Labor and Employment and other concerned government agencies to issue implementing rules and regulations, or what we call IRRs, to carry out and enforce the provisions of the labor code. So, Article 5 lays down the general principles and policies and ensures that these are translated into detailed workable rules that can be applied in the workplace. Note, class, that IRRs cannot amend, modify, or contradict the law. They must remain within the bounds of the statute. Okay. Article 6, the applicability of the labor code. Article 6 class establishes the principle of universality of labor protection. As a general rule, all rights and benefits granted under the labor code apply to all workers, whether agricultural or non-agricultural, unless the code itself provides an exception. Okay. Uh, the purpose for Article 6 is to prevent discrimination between sectors, ensure legal protection of labor, promote social justice across all industries, and historically, agricultural workers were more vulnerable. And so Article 6 ensures they are not left behind. Okay. Art um what is its applicability to government corporations? No, so Article 82 class of the Labor Code states or provides the general rule on the hours of work, stating that employees in all establishments and undertakings are required to render a prescribed number of working hours except for certain categories of employees. So, general rule, employees are covered by the labor code provisions on hours of work, overtime pay, premium pay, night shift differential. These rules are meant to protect workers from excessive or exploited working hours. Exception is under Article 82, government employees, so mga um, and managerial employees. Government employees class are excluded from the coverage of Book 3, no? Including hours of work. Reason because they are governed by civil service laws and the Civil Service Commission rules and regulations. Thus, their working hours, overtime, and benefits are regulated by public service law, not the labor code. Then the next one is managerial employees. So managerial employees are also excluded. So sila labot from coverage of hours of work. So kinsa man yung mga managerial employees? Those who primarily manage the enterprise or a department, customarily exercise discretion and independent judgment, and they have the authority to hire, fire, or recommend managerial actions. So the reason for this exclusion class is because they are not paid by the hour and are expected to manage their own time. Also, the applicability to government-owned or controlled corporations, no, or mga GOCCs. So, for HR implications class, for HR practitioners, correct classifications of employees is critical. Mislabeling an employee as managerial to avoid paying overtime is illegal. The coverage also depends on status, not on job title. Plus, Article 82 sets the rule but also the boundaries of labor protection on working hours. So, not all employees are treated alike, but exclusions must be strictly construed. Now, question: why are government employees excluded from labor code? So, government employees class, including those in government-owned or controlled corporations, were indeed precluded from bargaining as regards term and conditions of employment because these were set by law and hence could not possibly be altered by negotiation. Another question is, why do you think government employees are prohibited from conducting or staging strike against their respective agencies? So if private employees class are allowed to conduct picket or strikes, but government employees are prohibited. Why? Because the law prohibits strikes in the public sector because they prejudice public services. A 1987 case of Bangalisan versus Court of Appeals ruled that the right of government employees to organize is limited only to the formation of unions or associations without including the right to strike. One wrong cannot be righted by another, and redress for even the most justifiable cause should not be sought for prescribed or illegal means. So again, who are not covered by the labor code. So we have the specific exceptions, no, but uh it is important to emphasize that these workers are not totally excluded from the labor code. The exception applies only to certain provisions, particularly hours of work and related benefits. So we have small retail, service, and agricultural establishments. So retail, service, and agricultural establishments employing not more than 10 workers are exempt from certain labor standards, particularly on the hours of work, overtime pay, and premium pay. It is important to note, class, that they are not exempt from the entire labor code. So even if they are exempt from some provisions, employees in small establishments are still entitled to minimum wage unless specifically exempted by wage orders, basic labor rights, protection against illegal dismissal, occupational safety and health standards, social legislation like SSS, PhilHealth, Pag-ibig, where applicable. Now, take note, class, that exemptions rather, are strictly construed. So violation is still unlawful. Any violation of applicable provisions of the labor code remains unlawful and is punishable under Article 288. Employers cannot invoke small size to justify the non-payment of lawful wages, illegal dismissal, and unsafe working conditions. So for HR practitioners and managers, do not assume small business means no labor law. No? So determine which provisions apply and which do not. Always err on the other side of worker protection, class. Take note that non-coverage is the exception, not the rule. The labor code applies generally to all workers, and exemptions must be express, specific, and narrowly interpreted. So, small establishment, again, remember, they may enjoy limited exemptions, but labor protection remains the norm. Okay? Now, you read the case class, these cases on the concept on management prerogative. So we have 5 cases on concepts, and we also have um 5 cases on the limitations of management prerogatives. Okay, so I hope you learned something from this presentation. Thank you.